I'm not going to worry too much about the microphone myself, because people who know me know that I've got a loud voice, and I've learned to project it over the years. For those of you who don't know me, I'm Bill Wilson. I'm one of the magistrates here in the St. Joseph Circuit Court. I want to thank all of you for coming today. I think we have a nice set of presentations for you. At least I hope that they turn out to be nice. I think we will certainly, if you can hang around until this afternoon, I'm sure that you are all here just waiting with bated breath to hear Greg Blandford talk about civility in the courtroom. And I have full faith and confidence that he will have some good messages for us. Greg's been around the block enough that I think he has, he's learned a lot of things, as we all have. Anyway, enough picking on him. I'm really happy that we can start off this morning with Chief Judge Elizabeth Hurley from our sister court, the Superior Court over in Courthouse 3. One of the things that I have noticed, and I think any other judge has probably noticed too, is that rules of evidence, and especially hearsay, can be problematic. We all think we know it, and then sometimes I'll be thinking, well, this does not seem to be hearsay, but I'll get an argument from someone that, as Chief Judge Hurley said, it makes you start questioning your own understanding of the rules. And Judge Hurley has been teaching other Indiana judges around the state in our annual judicial conference, or the Spring Judicial College, for a few years now about evidence. She normally talks about it in the criminal world context, so we're getting her to broaden her horizons a bit. But I can't think of anyone that I'd rather have come in and tell us about it. So that's all I'm going to say. Judge Hurley, you have the floor. And I'm not sitting up here because I'm special. I'm sitting up here because I have these time cards to tell people, this is when your time is up.
Well, thank you all. And I know it's probably a little discouraging for all of you to hear that I'm the one, if you practice in front of me, that I'm the one teaching other people about evidence in the Indiana judiciary, because that bar might be a little low now. But I have been asked for the last, 2022, I think may have been the first time I was asked with another judge to teach evidence to our statewide judiciary at our conferences. And what we've learned, I'm also, fortunately, on the Judicial Education Committee for the Indiana Judiciary. So recently we did a needs assessment study to determine what it is that judges really want to learn about most, as we put together our annual conferences. And the top thing every time is evidence. Everyone wants to talk about evidence. Everyone wants to learn more about evidence. And hearsay actually was the top subcategory of the evidence needs that judges felt needed to be met, probably because it's what we see kind of most often as we're going through cases. The other thing that I've learned as I've gone through this sort of process of teaching is that Indiana Law School, in Indiana, only 2 of the 3 law schools require that students take evidence in order to, before they graduate. And so there's 2 of the 3 don't. And it's a trend around law schools around the country, is that evidence isn't required in many places anymore. And so what we're seeing as judges are newer lawyers, especially, coming in that haven't taken evidence. And when we were at our last conference, my co-presenter at the time said that he had had a person in front of him, a newer lawyer, not too new though, someone that had been practicing for a few years, who was trying to admit a video into evidence and continually didn't understand how to admit, which, as lawyers who've been practicing for any period of time, that seems like one of the more basic things that we would know how to do as a lawyer, is to admit something as easy as a video into evidence. And this person kept trying, the other side kept objecting, the lawyer kept not making the foundational requirement to admit the video. Finally said to the judge, well, can you tell me how to do it? And the judge was like, no, I cannot. So that's sort of what we as practitioners, not commenting on anyone here in the room by any means, I don't see that I see it, but practitioners around the state are seeing are people that might not be as skilled in evidence. And then you have the issue, like Judge Wilson said. I feel like I understand the rules of evidence to at least a certain degree, not claiming any expertise in the area, but I'll get an argument at times that does. I listen and I think, I thought I knew that rule, and this person's making the argument with real conviction, and so maybe I don't know the rule like I thought I did. So, hopefully people who have been in front of me would know that I'm not above just taking a break and going to look at the rule again, try to figure out the right answer. So, but a lot of times we have to make these decisions sort of on a split-second basis during a trial. And so these are the issues that are coming up the most. And again, these were the hearsay was the issue that seemed to be the one that needed the most work. So let's see if I can do this. All right, so let's just start with the rule. Rule 801, hearsay is what? It's a statement that's made out of court, that's offered in court as evidence, and it's offered to prove the truth of the matter asserted. So what hearsay is not. Hearsay is not a declarant witness's prior statement, and then the rule lists which types of prior statements may be admissible as an exception, not even an exception, an exemption from the hearsay rule. So a prior inconsistent statement made under oath, a prior consistent statement that's offered to rebut a charge of recent fabrication or improper influence or motive, or identification of a person shortly after perceiving that person, or an opposing party statement. So Rule 802 says that hearsay is not admissible, with, of course, the caveat, unless the rules or other law provides otherwise. So just a basic review of that. So what do we mean by the truth of the matter asserted? Because I think that's where the argument oftentimes is made. So a statement is offered for the truth if the statement's probative force depends upon its being true. If the statement has probative value aside from the truth, then the statement is not being offered for the truth of the matter asserted. So the thing that I have learned over time in going to a number of different trainings myself on evidence, and I say this at every single training I do, is this is the question. For what purpose are you seeking to admit the evidence? And so as judge, that's the question that I'm asking. So if you're in front of me, you probably have heard me say that. What is the purpose? For what purpose are you seeking to admit the evidence? I have it on a sticky note on my bench because that's the question that has to be answered. And if the answer to that question is the purpose is not for the truth of the matter asserted, then we can discuss whether or not that statement or hearsay evidence is admissible. There are obviously some other considerations that have to be made at that point. We go through then a Rule 403 balancing test. Is its prejudicial effect? Does that outweigh any probative value the statement may have? All of those questions still need to be answered, but this is sort of the first question that gets asked. For what purpose are you seeking to admit this evidence? So we can look at Rule 803 for some exceptions to the hearsay rule, and this is just a very short list. Rule 803 has a bajillion exceptions, but these are some of the ones that come up the most often. So we've got present sense impression, excited utterance. I would say in criminal cases we're seeing those all the time. Mental, emotional, or physical condition, then existing mental, emotional, or physical condition. Statements made for medical treatment or diagnosis, and records or absence of records of regularly conducted activity. I know when I started it was always regularly conducted business activity. That has been taken out of the rule, and it's just records of a regularly conducted activity. And then so 803, I'll go back to that, sorry, is those exceptions apply whether the declarant is there or whether the declarant is not there. So the declarant's unavailability is immaterial for Rule 803. For Rule 804, though, the declarant has to be unavailable. And so what I've listed here are just what makes a declarant unavailable. So if there's a privilege asserted, if the declarant refuses to testify about the subject matter despite a court order to do so, so we'll see those oftentimes in criminal cases, testifies to not remembering the subject matter can make someone unavailable. The person can be unavailable because they can't be present or testify because of a death or infirmity, physical illness, or mental illness, or is absent from the trial or hearing, and the proponent of the statement hasn't been able to secure their attendance through proper process. But there's an exception to that last one, and it's, I guess, colloquially known as the forfeiture by wrongdoing exception. So that unavailability requirement doesn't apply if the statement's proponent caused the declarant's unavailability or did something to prevent that person from attending or testifying. And so these are the exceptions then that are included. So if you've taken that first step and proven that the declarant is unavailable under one of those different categories, then these are the types of exceptions that fall under 804. So former testimony of the person, statement under the belief of imminent death, a statement against interest, statement of personal or family history, or a statement offered against a party who wrongfully caused the declarant's unavailability. So we're going to go through some scenarios now, and at the end of this scenario, I'm going to ask that you essentially pretend that you are the judge. So you can raise your hand, you can do whatever, but the question will be, you as the person who's making the decision, are you admitting the evidence or are you not admitting the evidence? Are you, sustaining an objection to the admission of the evidence or overruling? So the first scenario is, victim's on the phone. This is a criminal case. So victim's on the phone with her sister. She gets a call from her child's father. So she puts her sister on hold, takes the call from her child's father. A few minutes later, she returns back to the call with her sister, and the victim's sister asked the victim, who had called. And she said, it's my ex-boyfriend, father of my child. Sister asks victim what he wanted. Victim says that he wanted some money, and he told her that if she did not give him some, he was going to kill her. So that's victim's statement to her sister about what her ex-boyfriend, child's father, said to her. Later that night, the ex-boyfriend enters the victim's home, kills her, the roommate shoots the 3 children in the home, and the children survive, so he's ultimately charged with multiple counts of murder and attempted murder. At trial, the state asked the sister what the victim said to her about the victim's conversation with her ex-boyfriend's now defendant on the night of the murder. The defendant objects, arguing that the statement is hearsay. So again, if you're the judge, who would sustain the objection and not admit the statement into evidence? Okay, no hands, so everyone here would overrule the objection and allow the statement into evidence. All right. So this is the case of Amos versus State, and the Court of Appeals did hold that the trial court did properly admit the statement. The Court of Appeals said that the statement from Amos, the defendant, to the victim was not hearsay because that's a statement by a party opponent. So that in and of itself, that piece of the hearsay analysis, it was an exemption from hearsay because it was a statement by a party opponent. The statement from the victim to her sister was an exception to hearsay then under 803.1, which was a present sense impression. So there are 3 requirements then for the present sense impression. So it must describe or explain an event. So it must be during or immediately after its occurrence, and it must be based on the declarant's perception of the event. So in the Amos case, the victim described to her sister the phone call. She described it immediately after it occurred, and her description was based on her own perception of that phone call, that event. And so the trial court properly admitted that. Scenario 2. So in this case, a defendant is babysitting a friend's 3 children. Mom comes home after about 3 hours and finds the defendant passed out on the couch. Mom hears her 3-year-old crying, finds him in his crib with a bloody lip. Mom asks what happened to the child, and the child said that the defendant hit him in the mouth. Mom calls police. The police officer comes, speaks with the child. The child's still upset. Officer asks the child if he was hit with an open hand. The child says no, and shows with his fist how the babysitter had hit him. The officer then asks the child if he had been hit more than once, and the child says no. The officer then asked asked the child why he had been hit, and the child said that the babysitter was mad and because the child didn't want to go to bed. So the officer is interviewing the child, and these are the statements that the child gives about what happened. All right, so the babysitter is ultimately charged with battery to the child. And at trial, the state seeks to admit the child's statements to the mother and to the police officer. So as to the child's statements to the mom, is there anyone here that would sustain that objection and find that it's hearsay? So you would sustain the objection? Okay. And why would you sustain that objection?
Oh boy, Judge. Well, the first thing that came to mind is competency of a witness. How old was the child? My gut tells me I want the evidence to come in, so the baby should get punished if that's what happened. Well, I suppose he's allowed, he leads the witness. He asks her if the baby hit him. It is more than one piece of hearsay in there, Judge. I just don't feel comfortable. I would not feel comfortable.
How about anyone else? If you're talking about this child's statements to the mom, so mom comes home, sees the child's upset, sees the child has a bloody lip, and mom asks the child what happened.
Present sense impression.
Okay. Anybody else? So you would allow the evidence in as a present sense impression. Anybody else? Do anything different? Yeah.
It allowed it as an excited utterance. It appears that the child is still under distress with the thing that happened to him.
Okay.
But it's been about 3 hours and mom's been gone, so we don't really know exactly what's happened.
Right. Right. There's no indication about timing of any of it. We just know that mom's been gone for about 3 hours. All right. What about the statements to the officer? So the officer responds. We don't know how long it took for the officer to respond. The evidence in the case is that the child's still upset when the officer is talking to the child. And there's some questions asked, and the child gives some answers. So is there anyone who would sustain the objection to the statements to the officer then? Not allow those in? Mr.
Well, essentially it's the same basis.
Okay.
Hearsay and hearsay. That's
Sure.
what I'm saying.
Is there anyone that would let those statements in? You would let them in, Mr. Wiseman?
I would object to him if I was the defense attorney, obviously, but if the officer can establish that the child was still upset under the nature of the incident and not sufficient time had passed before he talked to the person, I think it comes in.
All right. So in this case, this is the Jones versus State case. It does say the trial court properly admitted the child's statements both to the mother and to the officer, which I thought this one was a little bit of a bubble with the officer when I was looking at the facts. And I think the interesting thing that I think we see at our annual conferences is when we're doing these evidence scenarios and kind of talking through them and all of this. And oftentimes we'll have, a way for the judges to sort of buzz in anonymously what their ruling would be. Because no one wants to actually say what their ruling would be and not, sort of follow the crowd. You would think at by the time we're at that level of schooling, people would be a little more comfortable with actually expressing what their own decision is, but people really like the anonymity of their answer submissions. But even on cases, like if you talk about the previous case on presence and suppression, which everyone here seemed to have pretty much the same opinion on, our room, and we normally have 100 to 200 judges in a room during these evidence presentations, it's almost evenly split for most of the fact scenarios. And so that's the thing with evidence, and especially, you know, these decisions that we're making on a, you know, again, on a sort of a split-second basis during a trial, is that people see them very differently. People have different opinions about what's admissible, what's not, and their judgment calls. And the Court of Appeals will often affirm the trial court's judgment. It's a, you know, sort of abuse of discretion standard on the admission of evidence. But, so they're oftentimes affirmed because a decision could go either way in a lot of different cases. And we see that. I mean, we see that just in these answers. It's literally, it surprises me, literally a 50-50 or 60-40 split in most of the scenarios that we present. And some of them I present, I think, that seemed like a kind of a no-brainer, like throwing out a, you know, an easy one there. But, so in this case, you know, I may have thought, if that evidence was presented to me, that the statement to the mom, you know, I would say probably maybe an easier decision. You know, mom comes home, child's crying, lips bleeding, mom asks a question, child says what happened. To me, that might be an easier call. With a police officer, you know, that's another however many minutes. By the time the police officer gets there, mom's talking to the child during that time, and then the police officer is asking a number of questions. And so I may say at that point, that might be a bit of a stretch for an excited utterance, but the Court of Appeals upheld the trial court's admission of those statements.
Of course they did.
Yeah.
But I'm sorry, how does this case intersect with Crawford versus Washington?
Well, I think that I don't, you know, there's no even Crawford discussion in this case. So I don't know if the child, they attempted to have the child testify. I don't know any of that. So it just was never brought up as an issue, but always, that's obviously if the declarant's not there and not testifying, then it becomes an issue in a lot of cases.
Thank you.
Sure. And I honestly, like, I had some Crawford cases or confrontation cases that I thought about putting in here, but I mean, I could, like, we teach normally like 90 minutes to 3 hours, and we fill it pretty easily. So there's so many issues and evidence that you could put in that at some point I had to figure out what not to put in. So what the court said, though, was that although the time of the battery couldn't be established, so somewhere in that 3 hours, but it could have been 3 hours, it could have been 5 minutes, the child's physical and psychological state suggested that he was not capable of thoughtful reflection and deliberation. And that's sort of one of the key discussion points about determining whether a statement is admissible. You know, is the person capable of that thoughtful reflection and deliberation before they make the statement? The court went on to say it was reasonable to infer that when the child talked to both the mom and the officer, he was still upset because of the stress of the startling event, and that the startling event caused the child the startling event that caused the distress was the physical altercation with the defendant that he described to both mom and the officer. And so I remember having, this case sort of brought this to mind. I had a situation where an attorney made an argument that a statement shouldn't be allowed in as an excited utterance because the statement was about the startling event. And that was the evidence of the startling event was the statement. And so it was kind of a circular argument that, you know, yes, there was a startling event, but how do we know about it? We know about it through the statement to the officer that clearly was an excited, would be considered an excited utterance. And I remember thinking, that was one of those situations where I sat and I thought, I don't know that I know the rule. I thought I knew the rule. and I don't know that I know the rule anymore. And it like sort of upended my whole idea for a little bit. And so I got off the bench and I went and I thought, and I looked at it, and I made a couple phone calls even. I'm not above like really getting as much information as I can before I make a ruling in a case. And I have some people on my speed dial that I call when I have these questions. And I talked it through. I said, I'm sort of caught in this loop of this question, and I don't know how to get out and make an answer or make a decision. And then I just said it was admissible as an excited utterance because the statement, the person was clearly under the stress of the event. There was evidence that a startling event had occurred. The evidence came from both her statement and, I would say, in my case, and some injuries. So clearly there's some independent evidence that a startling event had occurred. But it really gave me pause for a long time. So even on these rules that I think are somewhat simple, someone makes an objection or an argument, and it really just, it takes a while for me to actually come up with an answer to that or a decision. So again, here's 803.1 is excited utterance. It should actually be 803.2, sorry. So the three elements for excited utterance are that a startling event has occurred, a statement was made by the declarant while under the stress of the excitement caused by that startling event, and the statement relates to that event. So in that case, what I needed to do was just go back and look at what the elements of an excited utterance were, even though, again, I deal with it every day. Got, just sort of caught up in an argument, but once I went through the elements, I admitted the evidence. So, but again, 50% of my colleagues may have had a far different opinion and said, nope, that argument was sound. Yes?
Event. I think there was another section that talked about an event. Can it be a condition? For instance, it was so dark I couldn't see a thing, I was scared.
I would say that might be more of a present sense impression or a then existing mental, emotional, or mental state, kind of state of mind, versus an excited utterance. If something, I don't know but I don't know. I don't know the answer to that. I don't know if the darkness or the situation someone finds themselves in the darkness, it would be so fact specific, I think, as to figure out whether that could create an event that was so startling that it caused you to have this, make this statement that would fall then within these elements. But I do think it could very well fall under a different exception too. So, but I don't know in terms of event. I've not seen a case like that, but I'm not saying there isn't one. There very well could be. So an excited utterance can be made in response to a question. So if you're thinking about the officer asking the child the questions, so long as the statement is unrehearsed and is made under the stress of the excitement of that startling event. So I was concerned that the officer asked so many questions and that each one of those questions could continue to be an excited utterance, but the Court of Appeals felt that it fell within those elements. And it says, while the event and the utterance don't have to be entirely or absolutely contemporaneous, you do have to take into consideration the lapse of time in when making that admissibility determination. But there's a huge range of time frames that you find in the case law. I know there's a case involving an alleged rape where there was, I think, a 4-hour time frame in between the event and the statement. And the Court of Appeals found that that was admissible as an excited utterance because the person was still under the stress of that event. Yes?
Did they do any analysis of the kid's age? Because, a 3-year-old is never capable of reflection.
Really not. I mean, it was interesting. It was really, they focused on these elements and just how they fit in. There were a lot of considerations that I thought would have come up that didn't in this case. So, but again, I would have had a concern about not knowing what the time frame was as well. And I'm not saying I wouldn't have admitted it. I think it's just those are considerations that have to be made as that analysis is happening. But again, the heart of the inquiry is whether or not the person making the statement had the time for reflection and deliberation, and that's really, really fact sensitive depending on how startling the startling event was, how long it was for the statement, intervening factors, all of those things. I mean, it's truly a fact sensitive analysis. All right, so third scenario, another criminal case. I swear I have some civil ones coming as well. So 5-year-old gets a visit from her grandfather. The morning after the visit, discloses to the mom that the grandfather had molested her during the visit. Mom calls the police, takes the child to the hospital, and at the hospital, the child is examined by a SANE nurse. Ultimately, the grandfather is charged with child molesting as a level 1 felony. At the time of the trial, the child's 6 and testifies that she doesn't remember what happened with her grandfather. The SANE nurse testifies at trial and testifies about how she, sort of what her process is. And she testifies that she conducts a sexual assault examination. And when she conducts an examination, she first asks the child what happened. And she asks that question, so for purposes of medical diagnosis and treatment, to make sure there are no acute injuries to the child that need care, and to sort of assess what happened to determine appropriate treatment. The nurse then does a physical examination of the child. The nurse testified that she followed the same process in the case at issue, and the state then asks the nurse about that question that she posed to the child and the child's answer. So what happened, and what did the child say happened? The defendant objects to the admission of the child's out-of-court statements. The state argues that the child's statements are admissible because they're statements made for purposes of medical treatment or diagnosis. So, is there anyone here that would sustain the objection to the admission of the child's statements? So everyone here is letting the statements in. Mr. Wiseman?
Yeah, this is one that I've always had problems with, and I've done appeals on it and generally lost. But the nature of the questioning always comes into play as to whether the question itself is leading and drawing out responses. So I think you got to look at the entire factual scenario of how the questioning was actually done. If it was taped, so you can see it.
Right,
when
a child's in a medical examination.
That's always caused me problems in trials.
So, and presumably in a medical examination, the statement's not going to be taped. It's part of the, so you're probably not going to get that. But is there anyone here, so would everyone here then overrule the objection and allow the child's statements into evidence?
Perhaps with limiting instructions.
Okay. Well, in this case, the trial court erred in admitting those statements. And so yes, so in the worst named case of all child molesting cases, we have Wanky versus state. So what 8034 says is that a statement made by a person seeking medical diagnosis or treatment is made for and is reasonably pertinent to medical treatment or diagnosis, and describes medical history, past or present symptoms, pain or sensations, or the general causes of any one of those things. So in Wanky, what the trial court says is that to admit a statement under 8034, the proponent must show that the declarant was motivated to provide truthful information in order to promote diagnosis or treatment. So as adults, this is an easy situation. We know why we're going to the doctor. We're going to the doctor to get medical treatment. We're being diagnosed and we're getting treated. Just inherently, by us going to the doctor, we know what we're doing for the most part as rational adults. But what the case says is that young children may not know why it is they're going to see a particular treatment provider. And so there has to be evidence that the child understands the nature of the examination, why they're there, some evidence that would provide that, to show that that child was motivated to tell the truth during the examination. And so what this case lacked was any testimony by the SANE nurse about conversation that she may have had with the child about, you're here because we're here to, we're going to take care of you, if you have any, just some explanation. And I think now the SANE nurses now that I've seen on this are well trained enough to know to talk about that as part of their testimony, sort of when they're talking about how they conduct an examination, that's one of the first things they talk to the child about. Because there has to, again, be this sort of nexus between the statement being made and that motivation to provide the truthful information. And so, but because this case didn't have that, the statement, the court ruled that the trial court erred in admitting the statement. So again, it says there must be evidence that the child understood the medical professional's role in order to trigger that motivation to provide the truthful information. And that foundation can come through testimony of the medical professional that details the interaction that that person had with the child and how they explained their role to the child and sort of an affirmation from the child that the child understood that. But that has to be part of the evidence that's presented in order to admit those statements. All right, here we're moving into the civil realm. And I'm just going to front to all of you, I've been in the felony court now for 12 years, and so my civil knowledge is, so for all of you civil people here, if there are things you want to discuss, I will do my very best, but I might show a little bit of my ignorance on these issues in the civil cases. All right, so following a car accident, plaintiff files a complaint for damages. During plaintiff's testimony, counsel for plaintiff introduces certified medical records from the emergency room, the treating doctor, the admitting doctor, and the radiologist. The records contain opinions, diagnoses, prognoses, diagnostic x-ray reports, and notes from the admitting doctor. Oh, sorry. So I repeated that slide, but at the bottom there it says the defendant objects, arguing that the records do not fall under the 8036 records of a regularly conducted activity, which is how the plaintiff was seeking to admit those documents. So, if you're the judge, do you sustain the defendant's objection, or is there anyone here that would sustain the objection and not admit those documents? Mr. Blanford, why?
I'm sorry, I would sustain the objection because much of the records that came in had opinions that are verified that are subject to scrutiny. They're not facts, they're not data. It's information that is that individual made an opinion on. So,
all right. Is there anyone here that would allow the statements into evidence under that exception? Sort of what we call the business records exception, originally now records of a regularly conducted activity exception. All right. Well, I'm going to move on and let you know what actually happened. So we'll first talk about what 8036 says. 8036 says that a record of an act, event, condition, opinion, or diagnosis may be admissible as an exception to hearsay if the record was made at or near the time by or from information transmitted by someone with knowledge. The record was kept in the course of a regularly conducted activity of a business, organization, occupation, or calling, whether or not for profit. Making the record was a regular practice of that activity, and that all of these conditions are shown by the testimony of the custodian of the record or another qualified witness or by a certification, and neither the source of the information nor the method or circumstances of preparation indicate a lack of trustworthiness. So in this case, Brooks versus Friedman, the hospital records may not be excluded as hearsay simply because they include opinions or diagnoses. However, I think, Mr. Blanford, you were correct. The medical opinions or diagnoses must meet the requirement for expert opinions set out in Rule 702 in order to be admitted. So they're not admissible just because they contain hearsay statements, but other foundational elements need to be met in order to introduce records that contain that kind of information. So expressions of opinions within medical or hospital records historically have not been admissible under 8036 because their accuracy cannot be evaluated without the safeguard of cross-examining the person who offered the opinion. So the medical provider, includes the opinions in the medical records, but without any cross-examination of that witness or testimony by that witness to show how that opinion was reached, whether that opinion is valid, legitimate, the qualifications of the person admitting that opinion, making that opinion, then those records would not be admissible just as a business records exception. So if those other foundational requirements are met, those records can be admitted, but without those, historically, they would not be. Okay. So protective order hearing. Wife files for an ex parte protective order alleging that husband had threatened to kill her. The court grants the petition ex parte but sets a hearing. At the hearing, the wife testifies that she received a phone call from a county sheriff's deputy who told her not to return to her home because the husband, in the presence of his work supervisor, had resigned from his job, and said that the reason he had resigned from his job was that he was going to go home and kill the blankety blank, referring to the wife. The husband's employer notified police, notified one police agency. So this isn't a case that happened here in this community, but employer calls South Bend Police. South Bend Police then call the county police because the wife and husband's home is in the county. And then a county sheriff's deputy comes out and talks to the wife. Wife doesn't subpoena the employer or the co-workers or any police officers to testify on her behalf at the protective order hearing. And the husband objects to wife's testimony about, the statement that the county sheriff made to her about what husband said at work as hearsay within hearsay. So, is there anyone here that would sustain the objection to wife's testimony and find that it is hearsay? Mr. Grendel, why would you do that?
Hearsay within hearsay, there's no independent factual basis to support or well-reasoned fear. I could tell you that somebody threatened you. That's not the basis for a protective order against somebody.
Does anyone else have thoughts on that? Okay, was there anyone here that would overrule the objection and allow wife to testify about the call she received from the sheriff's deputy about husband's statement at work? All right. So Rule 805 addresses that hearsay within hearsay. And hearsay within hearsay is not excluded by the rule only if each part of the combined statement conforms with an exception to the rule. So in this case, we have Barger versus Barger. And the court said that the trial court erred when it admitted wife's testimony and granted the protective order since neither of the statements fell within an exception to hearsay. So we have first the statement by husband to the supervisor at work. Had the supervisor testified, that would then be a statement by a party opponent that the husband would have made, but the supervisor didn't testify. So the supervisor calls we'll say for our purposes, South Bend Police repeats the statement. South Bend Police call county police, who then repeat the statement to the wife and tell her not to go home. So again, had the wife, I think, subpoenaed the appropriate people, then that statement would have come in. But because the trial court granted the protective order based on that statement, the Court of Appeals said that the trial court erred in both admitting the statement and then granting the protective order. So those are all the scenarios that I have for us to go through. So if anyone has any questions or any other scenarios or things they want to discuss that pertain to hearsay specifically or evidence in general, things that have come up during the course of your cases, things that you see kind of often that you wanted to talk through, I'm happy to do that. But if you don't, then you have a session that ends a little early. So. Yes?
How often, I feel like this is used a lot in the civil area, effect upon the listener seems to be a really great workaround for almost everything, in my opinion. Why were you scared? Well, because they said he was going to kill him. No, that's not true for that. Sure, that it's effect upon the listener why you were scared.
Right.
Meanwhile, you can't unring the bell. So I don't know how
So I've definitely seen them in criminal, I've seen that argument made in criminal cases. And I do think, like every other evidence-based decision, sort of it's very fact-sensitive. And I think it depends on how far the answer goes, to a certain extent, as to, I think that questions can be tailored to not elicit what might be a very prejudicial statement, even if there's an argument that it could be admitted to show effect on listener. There is still that probative value versus prejudicial effect balancing test that has to happen. So if the statement being sought to admit is something like that, which essentially goes to the heart of probably the matter that you're there for, I think there's a strong argument that the prejudicial effect of that statement outweighs its probative value. And the other thing is that those questions, I think, can be tailored to not elicit such a prejudicial answer. There can be, it happens all the time. Lawyers have to sort of lead the witness through a question, or, so something super specific like what you're saying isn't stated in open court and a bell can't be then unrung. Without getting that entire statement in. But I think there is an argument to be made that effect on listener statements do come in if it leads to a logical next step of what happened, but I think there are ways to minimize the impact of its prejudicial effect. And I think before those statements are asked, those things need to be considered, because you're right, once it's said, it can't be unsaid. And I don't like that argument a lot. Effect on listener, I think it used to be used a lot more, and I think there's case law that talks about limiting that. You can't get into a police officer can't then go into an entire diatribe of why he did something or what someone said in order to cause him to do this, that, and the other thing. There are ways to minimize, there are ways to get that same information out about why the officer went and did what he did without eliciting such a prejudicial answer, if that makes sense. And I think that there's case law that kind of talks about that it can't be a super expansive way of getting statements in, that the prejudicial effect can really outweigh any probative value with that type of information coming up. Did that make sense, that answer?
Yeah, no,
Okay.
I feel sometimes as on the defense side of those talk, and that the intent is to get the statement out there, just trying to get a word around. It's a very important statement, of course, in the heart of the case, because you can't
Right.
say it. So.
And I do think, I think it's a legitimate argument to make for getting the statement in certain circumstances, but I think the counter to that, again, is the prejudicial. There still has to be that balancing under 403. And so while technically, yes, maybe that statement could come in to show the effect on the listener and what the listener did next and all that kind of thing, is it more prejudicial than probative? And is there another way to get that information in? Yeah.
There might be value for appellate purposes. Do juries ever heed limiting instructions?
Well, the Court of Appeals seems to think they do, because most of the cases that I read that deal with limiting instructions, it'll say, well, they gave a limiting instruction and we trust that jurors can follow the limiting instruction, and that was sufficient. But you're right, as a practical matter, I think it's difficult. Although having talked to many, many jurors over the years, it amazes me how much they really do try to follow what the law is, what they've been told through the instructions, whether the written instructions that they're given, at the start and then before they deliberate, or the instructions, limiting instructions that they're given during trial. They'll say afterwards, well, the instruction said this and you said this during court, and, so we didn't take that into account. So I will say, as a human being, I would think, they heard it. It's tough to say that they're not considering it. But in my discussions, most if not all, are really intent on making sure they do what the court's told them to do and making their decision. So I guess we can hold on to that hope. Anything else? Well, thank you. Thanks for having me.
Thank you, Judge.